Well, thank you very much, everybody, for attending, both those here in person and those watching online. I'm delighted to introduce Frank Hicks, SC, joining me to deliver a discussion, hopefully an interactive discussion, as much as possible with those online in relation to the High Court's decision in Tesseract. Frank will tell you in a moment about his particular role in the decision and why it's so fantastic that we've got a unique perspective that Frank can provide us this afternoon. Over to you, Frank.
Well, thank you, Stephen. And we're starting now. I hope that we have plenty of people online, because I must say that the in-person audience is enthusiastic, if small, but that's okay. I do feel a little like General Erwin Rommel being asked to give an account of the Battle of El Alamein, given that this is a High Court case in which I appeared for the respondent and managed to convince 2 of the 7 judges of the correctness of my arguments, but the other 5 not so much. So today is really about taking a fairly detailed look at the whole case and trying to ascertain what lessons can be learned for arbitration and indeed proportionate liability in terms of the practice going forward. We're obviously all aware of what the outcome was, that the High Court of Australia has confirmed that proportionate liability laws form part of the law of the land as it was described in GIO and Atkinson-Leighton, and as such will apply in arbitrations unless they are excluded by parties to their contract. Now, there's one major issue in terms of one jurisdiction that we probably need to mention from the outset, and that is that while some jurisdictions expressly permit contracting out, some are silent, there is one which expressly prohibits contracting out. And it's the one jurisdiction in which there's going to be quite a lot of infrastructure work going on in the next 6 to 8 years, and that is Queensland, obviously with the Brisbane Olympics coming. So there's going to have to be some fairly careful consideration by our Queensland friends as to how this finding in terms of proportionate liability affects any agreements to go to arbitration, and indeed the claims that one might wish to propound in arbitration, because obviously proportionate liability does not necessarily apply to all claims. It's generally those claims that arise from a failure to take reasonable care, whether that's in contract or as a matter of common law. And one of the things that I'll be seeking to explain, at least in terms of why this became a feature of this case, is on the facts, why those matters arose, what claims were being asserted, and how that then gave rise to the issue of proportionate liability. So that's the brief outline, and off we go.
I want to try and add something controversial to the discussion, and that's by referring to what Justice Stewart said in the conclusion of his judgment. And if you'll allow me just to read it out. His Honour stated, the result in this appeal highlights the limitations of arbitration. The fashionable trumpeting of the arbitral resolution of disputes may have overstated its virtues. Some disputes are better resolved in a court of law. That I want to suggest is the proposition that we are to grapple with. And in my experience, one generally finds people sit very firmly in one of 2 camps. One is either generally very pro-arbitration or pro-litigation. And if one accepts what Justice Stewart has said in what I've just read out, the limitations of arbitration have been exposed by this decision. But hopefully each of you will form your own view on that very question as we travel through the issues. Before we lead off, I just want to introduce the topics that we will be discussing so that you can familiarise yourself with the topics as we go. We've had the introduction, and I think Frank will now lead off with a discussion of the facts.
Yes, well, I will briefly outline the facts. Firstly, I might say that the arbitration is still ongoing, and it's due to be heard by the arbitrator, Wayne Martin, formerly Chief Justice of the Western Australian Court, probably around about August of this year. But in any event, the short facts were that Pascale Constructions was invited to tender to Bunnings for the construction of one of their famous warehouses in the Adelaide regions of South Australia. In order to prepare a tender for the bid, Pascale approached Tesseract, an engineering firm, to provide assistance in terms of the design of the structure that would be put forward. It was a design and construct contract, or intended to be. So Tesseract, which was then trading under a different corporate name, provided these design services to Pascale for the purposes of it ascertaining what cost it could then ascribe to actually undertake the construction based on the supports involving concrete platforms and structural steel, etc., etc. Pascale prepared its bid, put it into Bunnings, and was successful. And thereafter, entered into a design and construct contract with Bunnings for the construction of the premises, and also retained Pascale through a design services contract for the preparation of the designs that were then going to be used to fulfil the terms of the contract. After about 4 or 5 months of the initial work and some work being performed, the design that was prepared by Tesseract was reviewed by Bunnings' own independent consultant engineers, which I believe was Cardno. I'm sure I'll know by the time the case comes to trial. But and they observed that the design appeared to be inadequate for the loads that ought to have been accommodated by the various pallets and goods that were going to be stored, particularly on the second floor or first floor above the ground floor. That then resulted in certain assessments being made, and it was found indeed that they were inadequate. There is a dispute, I must say, as to the extent to which those loads had been appropriately described in the material provided to Tesseract, but leaving that aside for the moment. It resulted in Bunnings directing that the contractor, Pascale, remove what had been constructed thus far and to undertake a revised design and then install the works accordingly. This then resulted on Pascale's claim in various losses, including the loss associated with entering into the bargain on the basis of a fixed price, which turned out to be inaccurate and woefully underdone, having regard to the ultimate construction that was required, but also obviously the cost of removing the works that had been installed, the various concrete, etc., of the ordering of steel, and reinstalling all of that, as well as all the attendant costs of site supervision and project management and those sorts of things. So in that brief summary of the facts, what one can observe is that there was potential claims then made in contract arising from the design services agreement that was made at the time that the design and construct contract between Pascale and Bunnings was made. However, there was an anterior claim associated with the design that had been prepared by Tesseract to assist Pascale in making a tender bid to Bunnings. As a result, there were claims made by Pascale against Tesseract for misrepresentations arising from the design that had been provided for the purposes of tender and later as well, and also negligence, because there, at the time that those services were provided, there was no agreement. As a result, the claims became within the scope of both the South Australian Law Reform Act, which incorporated the proportionate liability provisions in circumstances where a claim is made for a failure to take reasonable care, but also the Commonwealth proportionate liability provisions which apply to the Australian Consumer Law under Section 87. The respondent, Tesseract, served a notice of defence in the arbitral proceedings asserting that one party was a concurrent wrongdoer a person by the name of Mr. Penhall, whose role was to assist Pascale in the preparation of its contract documents. He was not an engineer, or at least wasn't relevantly an engineer for the purposes of his activities here. And that then led to a question being asked of the South Australian Supreme Court under Section 27 of the Commercial Arbitration Act in South Australia, seeking to ascertain whether or not those provisions of the Law Reform Act and the Competition and Consumer Act, the Australian Consumer Law, could apply to the commercial arbitration proceeding in accordance with the Commercial Arbitration Act 2011. The South Australian Supreme Court decided that this was a matter of some significance and decided to hear it at first instance with 3 judges sitting at the appellate level, and they gave a decision in late 2022 following the hearing.
Was that because it was a pure question of law?
It was a pure question of law under the South Australian Commercial Arbitration Act. Sorry, I don't know if those watching along at home can hear questions from the floor, so I will repeat them when they arise, just so that you know what I'm at least trying to address. The question was whether or not this was a pure question of law. The answer is yes. Under the Commercial Arbitration Act in South Australia, and indeed in many jurisdictions, there is provision for a question of law of that kind to be remitted to the Supreme Court for answer, usually by consent and with the order of the arbitrator. In this case, it was all by consent. It was agreed that there was no utility in proceeding with an arbitration for, I think the claims are in excess of about $7 million at least, and it was thought that by all parties that it would be of no utility to undertake that arbitration and then have one party seek to set aside the award, either because the arbitrator had wrongly entertained a proportionate liability defence, or on the other case had refused to entertain a proportionate liability defence.
Frank, can you explain to us whether the fact that it was referred to the Court of Appeal, did that come from the court itself, or was that on a motion from the parties?
No, in fact, it was filed, and the first notification the parties got was that the Court of Appeal, the senior judges there, Justices Doyle, Livesey and Bleby, had decided that, or one of them at least, and Justice Livesey was the Chief Justice at the time. I think he still is. Forgive me, I don't know. But had decided that it was a matter of such significance in terms of the state legislation that, and probably, quite frankly, rightly, apprehended that whichever way it went, it would end up in the Court of Appeal one way or the other, to decide to cut through and to deal with it directly. I really don't know how that worked. Maybe they just thought it was a great wheeze and they'd like to have us hear about it.
All right. And Frank, in terms of the hearing before the Court of Appeal, I understand the Court of Appeal applied what was then the default position in Australia. Would you like to deal in a little bit more details to some of the concerns that were noted by the bench during the hearing before the Court of Appeal?
I probably would, given that this was the one part of the case that I actually won. But the situation, I mean, it is true that up until that point, up until the High Court decision, there had been other decisions in other jurisdictions which had held that proportionate liability was not available in arbitration for a variety of reasons. Those decisions had to be considered in light of the fact that in each of those jurisdictions, one was Tasmania and the other was Western Australia, it was expressly possible to contract out of the proportionate liability provisions. So the arguments that arose in those cases were largely, if not principally, determined on the basis that the parties, by electing to go to arbitration, had elected to exclude the proportionate liability provisions. But there was a consideration in both cases, and probably in the Western Australian decision of Curtin University and Woods Bagot of the more general proposition. And the sorts of issues that were addressed in that decision and before the Court of Appeal in South Australia, and indeed ultimately in the High Court, although in a much larger context there, was the question at its most simple or simply stated, were the proportionate liability provisions a regime intended to operate in whole in terms of the entirety of the provisions, both those which might be characterised, although not strictly speaking appropriately characterised, as substantive as opposed to procedural, or whether there were key or central provisions of the proportionate liability regime which could be applied, the basal principle that a party should only be liable for that much of the loss and damage which it has directly caused, rather than the old principle of solidary liability, which is, well, if you're a cause, you are liable for damages as a whole, and that is indivisible. And so that argument, or those principles, were variously debated in the decisions both in Tasmania and in Western Australia. And in each of those cases, the courts had formed the view that the proportionate liability provisions were intended to operate as a regime, and that to allow partial application of the key provisions or the central provisions would be to distort what Parliament had intended be the situation for the application of a proportionate liability to any particular defendant, and that the legislature had intended not simply to apply proportionate liability, but had intended to do so by balancing that extent of liability with the rights of the plaintiff to ensure that all issues were determined on the one occasion. There was a part of the decision in the Woods Bagot Curtin University case that was quoted by Justice Stewart, and I'll just see if I can find it amongst some of the many rather pithy references that we may come to. But the passage in Curtin University of Technology and Woods Bagot that attracted Justice Stewart's attention was this, a statement of Justice Beech, spelled B-E-E-C-H. It is one thing to decide to impose proportionate liability upon a plaintiff in the framework where the court has power to join other concurrent wrongdoers. To impose proportionate liability in the absence of such a power is a quite different thing. The absence of a power to join other wrongdoers has the prospect that a proportionate liability regime may cause injustice or hardship to a claimant. And the question really came down in many instances, or in each of the instances in which the matter was argued, was whether to apply those key features, central provisions, key operative provisions as they were variously described, whereby proportionate liability could be claimed without the attendant or concomitant ability of a plaintiff to ameliorate that circumstance by joining a party to the proceeding so that it had all claims dealt with on the one occasion, was really a central question that featured throughout the hearings.
Can I interject there, Frank? Because I think the point that you've raised is this question of joinder, and what we're going to find as we consider the various judgments of the High Court, starting with, as Frank has explained, how joinder loomed large in the opinions of the judges of the Court of Appeal of South Australia. The question about how joinder is a central issue in the application of the principles of substantive laws of arbitration, so that the different judges form different views as to whether the absence of the right of joinder would affect the outcome of the case before them. And I think it's really interesting how they fell on either side of that argument.
It certainly is. I mean, it was very much a question of the features and operation of the proportionate liability regime, because it was, quite frankly, accepted that there were provisions within each of the regimes, both under the consumer law and the law reform of South Australia, that simply could not be given effect in arbitration. One of the provisions, or each of them, had commonly a requirement on a respondent or a defendant who is the subject of a claim to give notice to the claimant of other potential concurrent wrongdoers. Now, the obvious purpose of doing so is so that the claimant can consider joining those other concurrent wrongdoers. It doesn't have to, and the fact that there was no requirement for joinder was something that some of the judges considered was important. It was submitted that it was a matter really for the claimant to determine whether or not to join those other parties, and it was their right or opportunity to do so that was expressly enacted in the provisions rather than any requirement to do so. That was considered by all of the judges, and certainly in the Court of Appeal it was thought that that right was essential to ensure that that right, I should say, was essential to ensure that the claimant or the plaintiff was able to take whatever steps it could or thought necessary to protect itself in the context of the proportionate liability regime.
All right, I think we now move to discuss the special leave application.
Before I do, I suppose I just did want to perhaps give another sense or flavour of what the South Australian Court of Appeal said, and I can do so by reference again to the decision of Justice Stewart in the High Court. He quoted at paragraph 278 the reasons of Justice Doyle, with whom the President, Justice Livesey and Justice Bleby agreed, in which it was said, "It seems to me that there are aspects of those legislative regimes that are intended to be integral to their overall operation, and yet which are inapposite for, if not incapable of, application in arbitration proceedings. Any attempt to apply those provisions to arbitration proceedings would result in a materially different proportionate liability regime from the one intended by the relevant Parliament." And that really was the heart or the nub of the debate. So, the South Australian Court of Appeal found you could not rely on proportionate liability. The Tasmanian Court of Appeal, in the decision of Aquagenics, found the same thing, and the decision of Justice Beach in the Western Australian Court had found in the decision of Curtin University and Woods Bagot that it was also inappropriate to allow a proportionate liability defence to be raised in circumstances where full effect could not be given to all provisions of the regime by an arbitral tribunal. And that then led to a certain counsel making a submission to the court on special leave that special leave should not be granted because the South Australian Court of Appeal concerned the matters of proportionate liability provisions, and that in respect of equivalent or similar provisions under other states' legislation, it had been consistent with decisions in Tasmania, Western Australia, and indeed Victoria, where that decision had where that issue had arisen, I should say. That then brought the rejoinder from the bench that, well, Mr. Hicks, that may just mean that the issue becomes even more important if they are all wrong. So, as a result, and interestingly enough, that rejoinder was given to the counsel that was making that submission by Justice Edelman. And we shall see that Justice Edelman was one of the two that I managed to carry in the final hearing. But nonetheless, he didn't like the notion that because 3 or 4 other courts had said something at an intermediate appellate level, that special leave should not be granted. But in any event, the same arguments were run as we've already adumbrated in terms of the submissions, or outlined, I should say, with respect to whether or not the Court of Appeal in South Australia were erred, or at least there was a question as to whether or not they had erred sufficient to warrant the granting of special leave. And the short answer is that the judges who sat on the special leave application, Justices Gordon, Gleeson and Edelman, as I've indicated, determined that special leave ought to be granted given the significance of this issue in respect of arbitration. I should also perhaps, although it didn't emerge so much in the special leave application, but it certainly featured later, particularly in the decision of Justices Jago and Beach-Jones, there was a question of the legislative intent and the policy, and perhaps reconciling what might have been seen to be an inconsistency between the two, in the sense that the purpose or policy behind commercial arbitration is to encourage parties to proceed to that forum insofar as they obviously can agree to do so, and to give full effect to parties' arbitration agreements, and so that any issue or dispute that might arise between them that might be ventilated in an arbitration agreement is done so, the liberal construction of arbitration agreements. But then also the question of the public policy behind the introduction of the proportionate liability regimes, which was obviously driven by questions as to the availability of insurance, particularly for professionals involved in construction projects and elsewhere, of course. But the old question of the plaintiff seeking to find the one defendant with the large pockets, or the deep pockets, I should say, in order to make the claim, knowing that it would be liable under the principles of solidary liability for the whole of the damages, even though, or even if, their breach had only a minor or even a major effect on the total loss and damage that was being claimed. So there was a question, at least, that occurred in the course of the special leave application, as the High Court's need to potentially resolve those public policy issues. And given that most of these issues arise at state level, it was thought best to resolve it on a national basis. There were no reasons given for the special leave application, I should be clear, but this is reading between the lines, or at least trying to understand what might be going on.
Was there anything said then that was a foretaste of what you encountered when you appeared before the full bench?
To an extent. I mean, the same sorts of arguments arose, but the questions largely resolved around the parties' ability to choose. And as we'll see, that was certainly a strong feature of the analysis that Justice Gagler engaged with, concerned that, can the parties choose arbitration? What does it mean when the parties choose arbitration? And there was, we'll come to it later, there was something of a fork in the road, I suppose, where the appellant was submitting that parties choose arbitration knowing that proportionate liability is part of the law of the land, if I can put it that way, and indeed putting it the way that the High Court did in GIO and Atkinson-Leighton, I should perhaps more accurately say. And do they therefore, does the potential claimant, and you may not know who the claimant's going to be when you enter into one of these arbitration agreements, but does a party, knowing that it might be a potential claimant, then take the risk that the opposing party may raise a proportionate liability defence, and it will not be able to join another party, and it will simply recover against that respondent for the amount that it can demonstrate is the result of that party's lack of care? Or, on the other side, do parties to an arbitration agreement agree to resolve their disputes as between them and them alone, and finally, to the exclusion of any consideration of the rights, liabilities or role of any third party in the process? So does the choice of arbitration, as was found in those other decisions I referred to earlier, demonstrate an election or a choice that arbitration shall be between them and shall not invoke the proportionate liability regimes? That was an issue that was very much front and centre in the debates before the High Court. It was an issue that each of the judges took up to a greater or lesser degree. Justice Edelman, I think it's fair to say, agreed with the respondent's position. Justices Jago and Beach-Jones, in fact, said it was a point against the respondent's position and found in favour of the appellant, and that a party goes into an arbitration agreement knowing that the law of the land is proportionate liability, even if it can't be applied to the arbitral process, and therefore it should be determined, in answer to the question we were dealing with earlier, that those provisions are applicable.
All right, Frank, shall we move to discuss the judgments of the majority?
The painful parts. Well, how do you want to do this, Stephen? Do you just want to do you want to roll?
Well,
through? Do you want to perhaps go first?
Well,
I'll comment.
The one particular feature of the Chief Justice's reasoning, I thought, was a bit different to some of the other judges, in that the Chief Justice considered whether the application of the model law and whether an award settling the dispute through the application of the provisions of the proportionate liability regimes would not be liable to be set aside under Article 34 of the model law. And when one compares the reasoning of the Chief Justice, it seemed to me that there was a particular focus on the application of the model law and the effect of setting aside an award. And I wondered, Frank, whether that had anything to do with the role that ACICA played in the fact that it was given leave to appear as an amicus curiae, and as I understand it, filed written submissions. And what role did that play insofar as the hearing developed?
Well, it certainly played a role in the ultimate decision, at least as far as Justice Gageler was concerned. From my recollection, and it is sort of 18 months ago, was heard in November 2023, so 17 months ago. The issue as to Article 34 and whether or not the award might be set aside as being not capable or susceptible of arbitration or contrary to public policy really didn't feature much at all in the oral address of the appellant through Brett Walker or myself. And I must say, I don't recall any questions being asked of us by the Chief Justice concerning how Article 34 and the question of whether or not any arbitral award might be set aside informed the question as to whether or not the arbitrator was then capable of reflecting upon and ultimately enforcing the proportionate liability regime. So to answer your question, Stephen, it featured in the ACICA written submissions. They were given leave to make written submissions. They sought leave to appear, and that was refused, as is ordinarily the case. But the ACICA submissions were not ones that either, although we had the opportunity, either party really sought to engage upon, because we had really drawn the terms of the dispute around the question of Section 28 and the applicability of the proportionate liability provisions, either as a regime or or not. So the key provisions and those sorts of things. So to that extent, it didn't really feature too heavily. Having said that, and whilst Chief Justice Gageler's judgment is obviously detailed and looks at the history of the UNCITRAL model and the drafting and the need for consistency, global enforcement and all those other sorts of things, he did ultimately address that issue of whether or not the proportionate liability provisions were a regime or whether they were separable, if I can put it that way, between what he described in paragraph 57, if I can just check my notes. Actually, I think he determined it at paragraph 63, where he said that what is important is the application of the central provisions within each of the state and Commonwealth legislation, and that the legal operation of those provisions on the rights or liabilities of the parties in dispute is not altered by the inapplicability of the other provisions within Part 3 of the state legislation, that is joinder and Section 11, and other provisions of the Commonwealth legislation, Sections 87 CE, CH and CG. So Justice Gageler took the view that the regime could operate inter partes without the attendant or cognate provisions that were set out in the Act, and it was not necessary for the whole of these provisions to be applicable or being capable of enforcement or being taken up in an arbitral proceedings for them to apply. And this was one of the key arguments, because the authority of GIO and Atkinson-Leighton that I was referring to earlier, one of the key passages that each of the parties referred to was whether or not the arbitrator could grant relief grant the rights to the plaintiff or to a claimant that a court could grant. I mean, that was a case about interest, and it was all a little bit historical, if I can put it that way. But the language spoke of the arbitral tribunal being empowered by the parties agreeing to go to arbitration to give relief as if a party was in court. And one of the arguments that the respondent, that we sought to raise, was that, well, the arbitrator couldn't do that, because one of the rights that was expressly allowed for under the proportionate liability regime was joinder, so that all issues could be determined at the one time. And as we'll see, the majority in various judgments said that that was merely procedural, or indeed didn't deprive the respondent from being able to call into aid those key provisions. So Justice Gageler used the term central provisions a couple of times to distinguish those fundamental parts of the proportionate liability regime from presumably what were non-central provisions associated with notice, joinder, Section 11 in the South Australian context, and the concept of having all issues being determined at the one time.
Frank, one of the things that I thought was a consistent theme amongst the different judgments was this question about whether a law of the state was substantive or procedural. Was there consensus between the parties as to what was a substantive law and what was a procedural law, or was there an argument about that?
The parties approached on the basis, and we did look at this in fairly careful terms, that the proportionate liability regime was substantive because it affected the rights and the actual outcome, the final determination of the entitlement of any one party. So there was a period of time when we as the respondent team considered whether or not we could argue that they were procedural and therefore was not part of, or were not part of, the substantive law that the arbitrator had to apply pursuant to Section 28 of the legislation. But we thought we just kept running into cul-de-sacs and just running into dead ends, and just it was, I believe, the correct decision that we approached on the basis that the whole of the regime was substantive. And although the judges did give some distinction between, as I say, central and they didn't use, Justice Gageler didn't use the term non-central, at least as far as I've read the decisions any number of times now. But the fact that some of these matters were perhaps on their face doubtless procedural, for example, the requirement to give notice of any other potential concurrent wrongdoer, that may have substantive consequences as well. It certainly has cost consequences under each of the proportionate liability regimes, but it was approached not so much on the basis of substantive and procedural as I say, central, non-central, key, not key, operative, or key operative, etc., etc. At least that distinction was drawn by the majority judges in each of the judgments to find that although there were parts of the provisions which were simply incapable of being given effect in arbitration, nonetheless those other parts were and ought to be applied.
Okay, shall we consider some of the other judgments,
Yes.
or is there any other points you wish to make?
No. The decision of Justices Gordon and Gleeson, again, really focused on this question of whether or not the provisions that were being debated were central, key, operative. The language that was used there to distinguish the provisions as to limited liability as opposed to the giving of notice and the joinder of parties, etc., was that the key operative provisions in each of the proportionate liability law could be utilised in arbitration. There was, if one reads the reasons, paragraphs 110 and 117 recorded that the parties accepted the operative provisions as to the operative provisions of the proportionate liability laws affect the existence, extent or enforceability of rights and duties of the parties to an action, and an arbitrator can apply those aspects with limited adaptations to fit the arbitral context without altering the substance of the provisions. Now, I haven't gone back to check the transcript, but I don't recall making any such concession or acceptance, which would seem to be fairly fatal to my whole argument if I had. But nonetheless, that's the recorded decision. I do recall that there was a much more back and forth about whether or not that could occur. And for example, I can recall, at least in broad terms, being asked whether or not the parties could agree that the proportionate liability provisions were applicable to their arbitration. And my response, at least in brief terms as I recall it, was, of course, parties could agree, if they wished to, that the proportionate liability provisions could be invoked if any party took action against the other under the terms of the contract, but that would require express agreement and there would need to be terms around it. So whether or not that is what is being referred to at paragraph 117, I don't know. But it's certainly capable, I would still say, for parties to agree that if one is sued by the other for a failure to take reasonable care, such that those provisions are ordinarily enlivened, and they're not enlivened in all cases, as we know, they're not enlivened in cases for breach of warranty and those sorts of things, that that party will be entitled to raise a proportionate liability defence and say, well, my responsibility or the liability I have for damages as a matter of causation for my breach is limited to X. And so that was always going to be available. But again, Justices Gordon and Gleeson did focus on what was described as the key operative provisions, and indeed at paragraph 128 stated that the possibility of joinder was not an integral feature of the laws. And that's really where the rubber hit the road, as it were, in terms of the arguments, because certainly in the decision of Curtin University that I'd referred to earlier, and indeed in the Court of Appeal, those judges had held, as we argued in the High Court, that it was an integral feature, that the possibility of joinder in circumstances where a respondent or defendant wished to invoke proportionate liability was an express feature of this regime, whereby the whole concept of proportionate liability was created. But nonetheless, we are bound by the High Court and those decisions, and as I say, both Justice Gageler and Justice Gordon and Gleeson, and as we shall see, Jago and Beach-Jones took the view that those features were not essential or integral or part of a regime.
Frank, I have a question that you may be able to shed light on, and that's this notion in the judgment of Their Honours Gordon and Gleeson, that the proportionate liability regime could be applied in arbitration as modified by the arbitrator. And what I had some difficulty understanding from the judgment is how could the arbitrator modify those laws? Was it dependent on the consent of the parties? or was it considered by their honours that that was within the power of the tribunal to in their words, modify the regime? Was that something that was developed in argument?
Yes and no. When going back to the Court of Appeal, when these issues were raised, and we were talking about the question of notice and joinder and these sorts of things, the response for Tesseract was, well, these were just rough edges; they get worked out, but they weren't actually. There was some submissions made as to how they might get worked out. You could draft an arbitration agreement that had various parties down the line, but we certainly focused on the fact that you couldn't modify the regime, at least in our submission, and make it work in the way that Parliament had expressly intended if you accept that joinder was a feature. Now, as we've seen, it was said, well, it's a possibility or an opportunity, but it was said not to be a feature, which was the conclusion reached. I don't want to necessarily rake over coals, not even hot coals, cold coals. But what really happened there, at least as we apprehended it, is that when you say the regime can be applied as modified means without application of those parts that can't be applied in arbitration. So there's no doubt that in arbitration, if a party is sued for, proceedings have commenced, you can give notice and say, well, these parties are concurrent wrongdoers, for whatever that's worth, because you can't do anything with it. You can, in theory, write to them and say, would you like to participate in an arbitration? And, in theory, that party might say, oh, yes, I would, and that sounds great. Who's your arbitrator? I don't need to know. I'd like to be in it anyway. And, of course, but that all, of course, presumes that the party who's given notice that these individuals are concurrent wrongdoers themselves consent to them being joined. So you could get a mischievous respondent who says, these parties are all concurrent wrongdoers, here's 6 of them. And the claimant says, well, thank you, I've given notice to them and 4 of them want to participate in this arbitration. And then the respondent says, well, I don't consent to that. I'd rather have them there as empty chairs so that I can run my defence as against you and I've got no one countering what I say except you. That's a clear potential outcome, because parties can only be joined to an arbitration not only with the consent of those parties, but with the consent of the parties to the arbitration. So it does have the potential for mischief making in the hands of a cynical party. I'm not suggesting any of those participating in our CPD would be so minded. So that was certainly one of the matters that arose, and one of the discussions that was had. Where were we with Justice Gleeson before I went off on that tangent?
We were talking about how the principle of modification will actually work in practice. Is that something that is dependent on the party's consent, or is that something that the arbitrator can, within his or her own power as the tribunal, to effectively mandate? And there wasn't. I had difficulty understanding how that was to be applied in practice.
Well, as I say, in practice, it's a matter of agreement, but if there's no agreement, you're simply stuck with the situation that the proportionate liability regime or defence, those central features, can be invoked. And if you can't get consent of all parties for a joinder, then as the claimant, you may be left having to commence separate proceedings in a court for recovery of any balance that is not received as a result of the arbitral award.
Frank, just on the point of joinder not being integral, did the majority go so far as to say that it was procedural, or they just said it wasn't integral?
The giving of notice was certainly thought. Sorry, the question was, for those that are online, whether the majority considered the question of joinder was merely procedural, or whether or not they simply said it was not central or integral. They did go close, certainly, to saying that there were features of the regime that were procedural, such as the giving of notice. There's no doubt that is procedural. It has cost consequences in each case, potentially. Although how you would enforce those, who knows, because ordinarily those cost consequences only arise when someone doesn't give notice and then runs the defence at trial, and someone has to, or a case has to be vacated as a result of the giving of notice. But they didn't distinguish between those features within the regime as one being procedural and the other being substantive, at least not as a major element of the reasoning. But to get back to your point, Stephen, that I think really the question of modification really simply means the non-application. Okay. So modification means you simply can't join. Well, you can try, but if you don't succeed, that doesn't mean you can get out from under any proportionate liability defence.
Okay.
Well, we've got about 10 minutes to go, so we might move a bit quickly. Plus, Justices Jago and Beach-Jones really didn't like many of my arguments, at least given the number of times that they said things like Pascale's argument overlooks the following. But in any event, their reasoning was if it wasn't me, I'd say quite good to read. But it does come down to the question that we have already been addressing, and that is that in their view, at least the question of these key provisions needed to be resolved. Their judgment also dealt with the question of whether or not Article 34 was significant, and their decision aligned or at least cross-referenced much of what Chief Justice Gagler had said, I should say, in the first decision that we looked at. They also addressed the question, as I averred to earlier, of legislative intent, and at paragraph 355 said, if the substantive provisions of the proportionate liability regimes did not apply in an arbitration, the common objective of both the Commonwealth and South Australian parliaments to ensure the viability of Australia's insurance market for professional services would conflict with their common object of ensuring effective arbitration systems for commercial disputes to facilitate trade and commerce. The legislative intention to be inferred is that both objects should be achieved. Effect must be given to that legislative intention. So they did wrestle, or at least deal with the fact that there were two legislative intentions being addressed in the two regimes, the Commercial Arbitration Act and the proportionate liability regimes, and they resolved them by finding, as I say in paragraph 355, that that was a fundamental aspect of how they should construe those provisions.
All right. Moving, I think, to the minority judgments. Minority judgments were delivered by Justice Edelman and Stewart, and it seems that in recent times those two judges of the High Court have more often than some of the other judges found themselves dissenting, and these particular judgments, I think, are noteworthy within which the forceful terms that they expressed their dissent. And one aspect of Justice Edelman's dissent that was a bit different in his reasoning to the other judges is that he considered that the substantive and the procedural rules of proportionate liability were so inextricably linked that it meant that the proportionate liability provisions should not apply. Now that, again, is a different feature of His Honour's reasoning compared to the other judges. Did you want to say anything about anything that Justice Edelman said in his judgment, or how he embraced your arguments before the court?
Well, I'd like to say I enjoyed reading them. But look, I probably wouldn't want to dwell on the decisions too much because it might sound a bit like sour grapes, or it really is unnecessary, because at the end of the day, no matter how expressed, they are minority decisions. I think what's most interesting, particularly in Justice Edelman's decision, which did approach the matter and the issues consistent with the way in which we sought to put the case, was really the postscript that he provided to his judgment. I mean, he was so concerned, it seems, by the majority decision, he didn't simply wish to dissent, he wished to add a postscript, which really made a fairly strong comment, if I can put it that way, on what the consequence of the majority outcome was for arbitration, and really, I think, was calling for legislative intervention.
Yes.
And thought that whilst the legal questions addressed and the reasons were not simple, the consequences of the decision may not also be simple. And that one consequence is that the widespread consensus concerning the proportionate liability schemes in arbitration, described in the opening paragraph of these reasons, and somewhat ironically, what he chided me for in the special leave application, can no longer inform the interpretation of arbitration agreements. And he said in paragraph 227, unless the legislation alters the law in some or all of Australian states, the result of this appeal is that the drafters of arbitration agreements must now be aware that the widespread consensus over the last decade no longer applies in Australia. Proportionate liability laws will usually, but not necessarily always, apply as part of the substantive law in Australian arbitration. So Justice Edelman was very concerned about the consequence of the outcome, given that it did represent a major change or shift in the way in which certainly the intermediate courts had all approached this question prior to this decision. Now, as I think Justice Edelman himself said to me, that doesn't mean they were all right, but it nonetheless does mean that everyone needs to reconsider their position and where they're at. And if they can contract out, that might be the best option. If they can have more extensive arbitration agreements, that may be the best option, absent some legislative intervention, and indeed where that is possible.
I think that the postscript in Justice Edelman's judgment is particularly interesting. It appears in paragraphs 225 to 227, and it's clear that His Honour was very focused on the practical impact on the practice of arbitration in Australia as a result of the majority's decision. And His Honour does say in the postscript that the outcome as found by the majority will not apply automatically to every arbitration agreement. In other words, those drafting arbitration agreements look very carefully at how you draft them and see whether you can manoeuvre your way out of some of the perhaps negative consequences of the majority decision. And then I think we will discuss very, very briefly Justice Stewart. And Justice Stewart also seemed to be very concerned about the practical effects of the majority's reasoning, and really considered that key. I think Frank picked up a point that was found by the Court of Appeal in South Australia, that key features of the regime were effectively missing, and therefore it was never the legislative intent that they could be applied in this way.
Look, I think that's right, and I suppose I can sum up the position best by simply quoting what Justice Stewart said at paragraph 264 of the decision. And he was dealing with the question of features concerned with enforcing obligations and identifying potential concurrent wrongdoers, and indeed joinder. And he said, without these features, the carefully calibrated adjustment of rights and obligations found in each proportionate liability regime is distorted. What is left is a misshapen parody of what was intended. Those features also reflect an expectation or an aim in cases of apportionable liability, namely that all claims will be resolved in the one proceeding. And he refers to some extrinsic materials that he addressed concerning the drafting of the legislation, going all the way back to 1996, when the first papers on these matters were considered. So Justice Stewart was very much of the view, at least by reference to that paragraph, that the Court of Appeal in South Australia was correct, and you needed to treat this whole as a regime and not simply apply the what were described as central provisions, key operative provisions, quote-unquote integral features to the exclusion of those other parts which were intended to balance up in favour of the plaintiff or claimant the position where a respondent or defendant can invoke proportionate liability.
All right. We thought that we would discuss briefly some of the potential impacts of the Tesseract decision. And I think this obviously loomed large, Frank, in the arguments that you made, and that's the necessity now for claimants to commence court proceedings to recover the full extent of their loss, in addition to, of course, the existing arbitration.
Well, of course, a party to an arbitration agreement is bound to go to arbitration but under the terms of the Commercial Arbitration Act. Before the current form of the Act, which I know goes back at least in New South Wales to 2010, but prior to that, there was obviously the option of commencing proceedings and seeking to convince a court that arbitration was not suitable for your dispute, particularly where you had multiple parties. And indeed, one of the high watermark cases there was that of Savcor in the state of New South Wales, which is obviously no longer of any use, particularly on statutory construction, because the relevant provisions that it was concerned with have been repealed. But yes, it does create a circumstance where if you are party to an arbitration agreement and there's been no agreement to exclude these provisions, if such an agreement is available, then a claimant is potentially left with having to commence proceedings in another place. One of the things I suppose I would mention is that obviously these proportionate liability provisions generally have limited application, and they obviously are applicable in misleading and deceptive conduct cases or ACL cases. They're also applicable to cases about failure to take reasonable care, which most commonly arises in negligence, can arise in contract, of course, but if a party has available to it a sound contract claim for, say, breach of warranty, and one is concerned about the possibility of any sort of defences being raised, then obviously that claim is not susceptible to proportionate liability defence. And therefore, if you confine your claim to those claims which are not answerable to a proportionate liability defence, then that is a way to avoid this whole circumstance. As I described the facts in this case, it was unavoidable given that much of what is said to be actionable occurred prior to any contract being made.
It seemed to me Justice Stewart was particularly concerned about this problem about inconsistent findings in circumstances where there are multiple proceedings, both arbitral proceedings and court proceedings. And then there's this question, I think, that's left unresolved, and I think Justice Edelman also was very alive to this. And that's the extent to which a third party would be bound by an award in arbitral proceedings. And Frank, one thing that I found particularly interesting that is perhaps pertinent only to the law of South Australia, and that's the effect of Section 11 of the Law Reform Act of South Australia. Would you like to explain the impact of that?
Yes, it really is a feature only of the South Australian law, but what part of the proportionate liability regime in South Australia involves Section 11, which says that the first judgment in time then sets the nominal damages and indeed the extent of proportionate liability for the party to whom that judgment is obtained, so that a subsequent proceeding, which might be commenced, means that the defendant in those subsequent proceedings is left with findings that they had no role in obtaining, had no right to be heard in the case of an arbitration, and are simply presented with as set. Now, as I say, this is a particular feature of Section 11, but it was certainly something that we were concerned with and were repeatedly pointing out. It was certainly something the Court of Appeal in South Australia was very concerned with. The decision of Justices Jago and Beach-Jones addressed that to some degree by saying, well, an arbitral award can always be enforced by having it made a judgment of the court and proceeding accordingly. and in those circumstances they were not so concerned with the operation of Section 11, but certainly it was a significant feature in terms of Justice Edelman's decision at let me have a look. Yes, paragraph 200, where he said that the proportionate liability schemes do not merely limit to operate the liability of wrongdoers, but also to distribute the liability of wrongdoers. The provisions of Section 11 is the clearest of this effect. It requires, in the example of A, B, C and D, that judgment first be given that determines, for the purposes of all other actions, subsequent actions, the notional damages of A that are recoverable from B, C and D combined, the proportion of liability of B, C and D, the extent of any contributory negligence of A in relation to B, C and D. So it has quite significant consequences in South Australia, so that in this particular example, A sues B, the arbitral award comes down, there's a finding made in respect of A's notional damages, the proportion of liability of not only B but C and D, and the extent of A's contributory negligence in respect of those matters. And in this example, parties C and D get told of it after it's all happened and are stuck with it. So, a problem if you're in South Australia.
And speaking of problems that are local to a particular state, Frank indicated early on in the seminar a particular feature of Queensland which prohibits contracting out of proportional liability, and the looming impacts of that on infrastructure projects as we run up to the Brisbane Olympics. I would be interested to know whether some in the arbitral community think that the impacts of Tesseract are overblown, because in states such as New South Wales, Western Australia and Tasmania, one can contract out of proportionate liability. One aspect that I've encountered arbitration practitioners to say to me, well, one possible impact is that people will include as the governing law clause of the arbitration agreements England and Wales, so that you won't have this problem at all. And English Council think that's a fantastic idea. The other proposed resolution is looking very carefully at the contract model, and that's deciding at the outset, having all relevant contract parties effectively together at a very early stage, working out who would be at the downstream level relevant parties, and to try and get uniformity amongst everybody, so that there is, for example, an agreement that disputes are all arbitrable, for example, and to have clauses which provide for express rights of joint and consolidation. And so there seems to be a view that, amongst some at least, that Tesseract is not the doomsday scenario, as Justice Stewart has perhaps suggested, as I commenced the discussion with, because there is a potential solution, and this is at least one of the solutions that have been offered.
So just on the point about including all relevant third parties,
yes.
Does that mean that up till now it's very rare for cross claims to be advanced in arbitrations?
Well, it depends on.
Against third parties.
Yes, because you come back to this joinder problem. Whether the third party is part of the contract relationship. If they're sitting outside it, as Frank said, why on earth would you consent to becoming part of a dispute when you don't have to? So this notion requires, I think, a fundamental shift in the contract model, in that all relevant parties have got to get together at a very early stage and plan for the worst case. which, as you know, usually the dispute resolution clause is the midnight clause, and so I think requires a fundamental shift in thinking about how to resolve disputes because of this problem. So I think it's an interesting proposed resolution, but I don't, I think time will tell whether it's effective or not. But certainly I think it's, again, there seem to be two schools of thought. One is, well, this is just an overblown problem and there's an easy resolution, and that's the resolution. And the other is, well, those who've previously automatically lunged for arbitration might have pause for thought as a result of this decision. Well, I wonder if there are any other questions, and thank you for those who've attended here in person and for your interest. Hopefully, Frank, whilst revisiting Erwin Rommel's position, you haven't had to take the cyanide pill.
No, I'll just have to report to the Führer. So, explain what happened in the bunker. But look, thank you very much, Stephen. It's been a pleasure to be a party to this panel. We have gone a little bit over time, so we might just leave it there. If there are any questions or if we can assist at all, obviously we're available through our clerk, Joe McGoldrick, or directly by email, so please don't hesitate. Even if you've just got a question about something that's been said, always happy to talk. So thank you very much for your attendance, and I hope it's been somewhat informative for you.
Thank you, everybody.